Good evening, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. Thanks for joining us. Tonight is Tuesday, so what does that mean? Yes, first we start off with our live show here, and then we go to our Patreon show immediately after this, where in the Patreon show you can actually call in. We give you a number, and you can call in and chat with me, and we'll talk about anything that you desire. But it's usually about cases that are going on and legal matters related to those cases. So please join us. Hopefully we'll all have a wonderful time. Usually I think the Patreon's been really, really good. We get a lot of people to join immediately after joining us here for our live show as well. All right, so tonight we are streaming both YouTube and Facebook. And I know there's lots of people that don't subscribe to Facebook. We get it. But if you like our Facebook page and you subscribe, like, and share, you will be given a opportunity to win. So the first 100 people that share will pick one person. They'll win $100. And we'll do that up to $500. So you have multiple chances of winning, I guess, there if we include the people that didn't win on the second one, from the first one to the second one. But either way, we're giving away money. Why? Yes, we're trying to get you to subscribe, like, and share on our Facebook page. Got to get those numbers up. I'm told that it matters these days, so let's give it a shot. If you don't go to Facebook, I understand. That's what YouTube is here for. But don't forget to follow us. We are on Instagram. We are on Twitter. We are on TikTok. We are on Facebook, Instagram. And you can download us on any of the podcast apps. So if you say, hey, I just haven't had enough of my fix of listening to Scott Reisch and his witty personality and dry sense of humor, you can go back and listen to previous podcasts that we put up, going all the way back to the beginning. Yes, you can. All you have to do is download Crime Talk on your favorite podcast app. So do that as well. So tonight, what are we going to talk about? Well, there's always something to talk about out there in the world today when it comes to crime. Hopefully you all have had an opportunity to watch today's video that we put up. Obviously, violent crime is on the rise just about everywhere. We talked about, New York, the typical, all the usual suspects, right? Chicago, New York, Philadelphia, LA, going through the roof, but other cities as well. And we're not talking like, it's up a couple of percentage points. We're talking up almost 100%, 80%, 90% in some of these cities. Now, yes, people are going to say, Scott, you're just a defense attorney. You're going to say that's great for you. No, right? I still want to live in the community in which I work, all right? And just like some people, we kind of were a little snarky today because I said, I made a comment the other night on a video about, I've said this once, I'll say it again. If you're going to commit a crime, don't take your cell phone. Oh my gosh, Scott, how dare you? How you're telling people how not to commit crime. No, okay? It's just common sense, okay? And we talked about it. I mean, look at the Lori Vallow, Chad Daybell matter, right? We've talked about this. You can probably go back and look at videos. It's the cell phone data that's going to get them. It's what's saved from the cell phone, from the iCloud apps. It just took time to get in there. Now, I think there's some real legal issues in there that could work somewhat to the detriment of the prosecution. We can talk about that. But it's just common sense. I mean, this little bad boy you carry around, it is saving, collecting so much information. It is unbelievable. And I'm not counseling people saying, don't take it if you're going to commit a crime, okay? Don't commit crime. Does that satisfy everybody? Don't commit crime. I've said that lots of times. Don't take things from other people that doesn't belong to you. Don't go into homes that don't belong to you. Don't do anything to other people if they don't consent to it, right? Those kinds of things. And by saying the cell phone data, and we've all heard about where the Siri or the phone, records, or there's some sort of data out there. It's just common sense. All the information from the Wi-Fi networks, the searches that you do. This is the greatest investigative, I wouldn't say tool, but it could be essentially, I guess, if you look at it, but the greatest cache of information about what somebody's done. Think of all of the apps that you have running in the background of your phone at any given time. And if you read the fine print, that's why the little microphone is allowed to stay on. It's like, wow, I was talking about widgets. And what a coincidence. I just started to get stuff in my social media feed or even Google regarding widgets. What a coincidence. That's because there's an app running in the background where you clicked on the terms of service that you didn't read, like I'm guilty of it too, and they can monitor that type of, conversations. You consent to it, right? The question then is, can the police get to it? How can they use that to solve crimes? It's not as easy as you actually may think, because this little bad boy is considered privacy of yours, right? The Carpenter case, the Supreme Court case, you have an expectation of privacy in your phone, in your data. And so how can the police go get it? So we'll talk about that in a little bit as it relates a little bit, for example, like to the Lori Vallow matter. That there's a treasure trove of information out there that has come out about, pictures and things like that, emails that were sent that probably were the last pictures taken of, for example, of JJ and Tylee, specifically JJ, that's been released. So, no one's telling you to take crime. It's common sense, okay? But you still have an expectation of privacy of it, and I think it'll be interesting when we talk about that here in a bit. So let's talk a little bit else. For those of you who've never joined us before, my name is Scott Reisch, and I am a practicing criminal defense attorney. Been doing it for 26 years, 21, I guess, starting 21, in my own practice. Handle just about every type of case you could possibly imagine. So when I'm telling you what's going on, I'm speaking from experience. I don't know all the answers, and my opinion may change on a case, because all things in life, just like the law, you try to give your best advice based upon the information that you have. And once the new information comes out, then our advice may change. I've had to change my advice lots of times where something's really good. I have a client that has a great case. And then, maybe they break up with their girlfriend and their girlfriend says, let me tell you what he told me. Client says, what happened? Well, you upset your girlfriend and she's now upset, and she told the police everything that you may have done, or vice versa, male, female, doesn't matter. But the point is the evidence has changed, and now my opinion has changed in saying, yes, you need to probably take a disposition, take a deal in the case. So that's where it is. I'm going to tell you, like I tell my clients, right? I tell my clients, why would I intentionally give you bad advice? I wouldn't, okay? I want to give you my best advice. Do I like being correct? Yes, I do. Am I always right? No. And if I am not correct, I'll tell you where things went wrong. But I think I have a pretty good track record of kind of calling it the way it is. I think the first one was when they added on the Chris Watts case somewhat unexpectedly. I'm like, well, there's either a couple things. Either A, they're moving to continue the preliminary hearing to a new date and with the agreement of the parties, or B, there was going to be a plea agreement. Called it. Yeah, that's right. Just from experience. And like I said, there's lots of people that want to talk about true crime. True crime is a fascinating area. It absolutely is. And I get it, why people love it, the fascination, the psychology of the people that do it. How do they get away? The science that comes with it, the forensics. and then the legal side of it as well. All super fascinating. And so then, obviously the issue is, do you want to know how legally it's going to play out? Or do you want to, I got in a little bit of trouble for this a couple weeks ago. Ooh, speculation. Yeah, and we can sit and speculate all day long. But guess what? I can't do that with my clients. My clients have deadlines. They have decisions to make. And like I said, we can sit here and speculate all day long. But it really doesn't matter. And what matters is what the prosecution can prove. That's it, right? It doesn't matter whether your client is guilty or not. It's what the prosecution can prove. A lot of people may not like that, but that's what it boils down to any day. You ask any seasoned prosecutor, they will tell you that immediately. They have people that they think are guilty. We have people that we think are innocent, or maybe not guilty of exactly what they're charged with. And a good prosecutor will tell you. So it's not just me, hopefully not coming across as just a jerk, but a good prosecutor will say, it doesn't matter what I think. It only matters what I can prove. And I have to tell that to clients as well. It doesn't matter anything. Only matters what they can prove. So there we go. So we talked about why listen to us. Who am I? Like I said, the topics are really going hot these days. Obviously, Lori Vallow, is she crazy, not competent crazy, or crazy like a fox? We'll have to wait and see. We have, what has she been down at the state hospital for roughly maybe 30 days now, I think. Don't hold me to that exact number, but 30 days plus or minus a week there. We have information being released from Arizona, Chandler, Arizona. And we can put this up, and I don't know if you all have seen, for example, the reports of Alex Cox that was put up, that's been released, and we're getting all this stuff. But I really wonder, and this is what we talked about in today's show. That's why you should go check out the video. We can talk about it now as well. I just do not see why Alex Cox was not charged. Okay, and I'm like I said, coming from somebody that's been a prosecutor and a criminal defense attorney, I'm telling you, you got a dead body there. Okay, this is not the strongest self-defense case I have ever seen. In fact, from my position, I would say, if I was advising a client, I'd say, well, why'd you shoot him? Okay. You say you got hit in the back, but basically, just kind of bounced off you. And then, I think we've learned that Charles Vallow, apparently was pretty athletic. I think he played baseball or something, and if he was going to swing at somebody, probably would do some pretty severe injury. And then now we know that the ballistics didn't exactly match up to what's the word I'm looking, didn't match up to the story that Alex Cox gave. Why did that take? That took place back in July. Almost 2 years to come to the conclusion, hey, I don't think this Alex guy wasn't telling the truth. If I was the lead detective in the case or the prosecutor reviewing this, and it says, Alex told me he never considered Charles to be a threat before today. I asked Alex about grabbing Charles around his shoulders and then falling to the ground. I confirmed with Alex that he never saw Charles swing the bat at him, and he said that was correct. I asked Alex what happened right after he got up, and he told me after they went to the ground and separated, he was getting up, and then he motioned. That is when he got hit in the back of the head, and his head bounced. I confirmed with Alex that he was getting up from the ground. That is when he felt the strike to his head, and he said yes. I asked Alex what he did after that, and he said he went straight to the room. Alex said he was hoping this would calm down. I asked Alex what he thought would happen when he confronted Charles with the gun. And he said he thought Charles would back down at that point, but he did not. I asked Alex if there was anything else he could think of that I needed to know, and he said he was not sure. I asked Alex if he needed to have his head treated, and he said he would like to get his head cleaned up. I asked Alex how the injury to his arm happened, and he said it must have happened during the struggle. Asked if there's any physical fighting. He said only pushing during the struggle. I asked Alex about his criminal history, and he said he has a previous aggravated assault in Texas, and he had his rights restored. And the reason why the police officer asked that is, if you've had any criminal cases and you're a felon, you cannot possess firearms. So why are you possessing a firearm and shooting people? And most states are going to have a self-defense instruction that is going to say that you can only use, reasonable force, and you can only use deadly force if basically you think that you are in fear of imminent serious bodily injury, break of a bone, a fracture, something along those lines where you think, my God, I am going to die. Okay. And in most jurisdictions, you don't have to retreat first. And here, this gets into a real tricky area. You're having a struggle. You get hit. You go into the other room. You come back out with a gun thinking you're going to calm the situation down. And then you shoot the guy, but he is not swinging the bat at that time. And he doesn't even really say that he's coming at him at that time. And, like I said, I'm just reading it and I'm thinking, I just don't know why. Maybe they just figured, hey, no rush, family squabble, no big deal, whatever. And I'm not throwing stones at the Chandler Police Department. They're doing the best they can based upon the information they have. But I read that, and my first thought would be, oh, you're going to be charged, man. At least, some sort of equivalent like a second-degree homicide. And just think, had they charged that, would things be different today? Let me know. Let me know what you think. All right. Also, we're going to take questions from everybody today. Now, understand, we sometimes these comments go by scrolling by very, very quickly. And for me to see them, I have to keep my focus and try to see that. Now, we don't solicit for super chats, but I can tell you the super chats clearly pop up on my screen. They're highlighted. So it's pretty likely that I will probably see that if it goes by there. But this is the time for the show where you all can ask questions about really anything, about any case that's going on, and legally how things happen. We had a great caller the other day on the Patreon show that wanted me to explain impeachment. What does it mean to impeach a witness? And I explained that. And those are the kind of questions you can ask. What does this mean? You don't have to just say, hey, what's your opinion on this case? There's lots of questions. A lot of people that watch trials, and they, sometimes have questions. And remember, if you have a question, that means probably, another 100 people have a similar question, and we're worried about answering it. Ask a question, because nobody is going to criticize your question at all. Now, a lot of people are here talking about the old phone thing, and they're saying, use a burner phone for stupid stuff. My advice is I wouldn't even use a burner phone, okay? Now, let me tell you a story. Some people like my stories when it comes to phones or to real life stuff. Other people are like, hey, I only want to hear about the cases that are going on right now. But do you know, for example, if you go into a cricket store, all right, learn this in a case, and it was pretty commonly known because you would oftentimes get cases where they were looking at phones, and if it was a cricket phone, they really didn't ask for an ID. Basically, anybody can come in and say, here's my name. And it was always registered to like Al Capone, Scarface, things like that. And so they couldn't, they always had trouble sometimes linking it to the client for sure. And had a case, it was trying to say that this particular phone belonged to this person, and that was it, and therefore it's the same person. It was let's just say it was a large-scale drug transaction. All right, and as a general rule, large-scale drug transactions, there's usually nobody's there that shouldn't be. All right, except maybe law enforcement or something like that. And anyway, they were trying to say, well, this is the phone that the person called, and that was it. And, basically the defense was, wrong guy. You didn't have any pictures. You didn't have anybody, and all your witnesses suck. And we were doing it, and they said, well, here's the phone. And they brought in the person from like a cricket, and they said, no, all it's registered to is this particular person. No identification was given. Okay? I mean, don't blame CrimeTalkWithScottReisch for this, okay? You can't blame CrimeTalkWithScottReisch. All the phone providers that don't require an ID, there's actually some that don't. So I'm going to go in, get a phone, no ID. And they just said, okay. They brought in the person from the telephone provider and said, all right, are you the custodian of records? And many people don't know this, but phone providers have individuals that are custodians of records, and all they do is fly to court and authenticate records. Facebook
chat, if you want to.
Oh, Facebook chat. Oh, okay. Yeah. So there are people that work for these telephone that actually just come to court and authenticate the records and explain, here's what the call logs mean, here's what tower it brings to, who's the name the phone is registered to. That's all they do, right? Those records do not just magically fall into evidence. And sometimes the phone records, the stack will be huge. It'll be hundreds of pages. And like I said, you have to be able to get them into evidence. And those records are business records. And business records can be sometimes self-authenticating, but normally you need a custodian of records to explain how the records are kept and what they basically mean. So, for example, in a white-collar crime case, you bring in the bank records, right? You bring in the bank representatives. Are you the bank representatives? Yes, you do. Do you keep bank records at your bank? Yes, we do. Are they accurate? Yes, they are, right? Because they're in the business of keeping accurate records. And so somebody comes in, they do that, they lay the foundation, and then they move for the admission. Then they normally bring in one of the investigators to say, have you looked at these bank records? Have you analyzed them? The money coming in, the money coming out, the expenses, blah, blah, blah. They do that. Same thing as it relates to phone records. Somebody comes in, do you have a phone record? Yes, you do. And my real problem with this, and I understand it, but I almost kept these records out once in a drug case where I asked to voir dire the witness. And I was like, ma'am, you're the custodian of records, correct? Yeah, and you're here. You don't know anything about this case. You were just told your next stop is Denver, Colorado in the U.S. District Court. Yeah, that's pretty much what it is. You don't know anything about this other than what's here today. That's correct. And your job is to literally fly around and do this at courtrooms several times a week. Yes, she responded, that's correct. And these records, they're out in this digital data land out there somewhere, right? And you did not create these records. They weren't created in this form here today until the government asked you to do so in anticipation of litigation, correct? And the lady says, well, that's correct. Your Honor, this document was created in anticipation of litigation. It is not a business record maintained in the normal course of business. And the court had to think about it. And he's like, well, I think it's all digitally located up there in all this little digital form. And then they just process it into a form where we could all use it and access it. The court was probably right, but it's always fun to try and, kind of mess with them in that regard. Not mess with them, but, lay the foundation, let people know, make a record. That's what the people, they do. So whether it's a phone records case for authentication, for identification, trying to prove that identification, those records don't just show up magically. And if a prosecutor doesn't bring the right person, I won't mention any names, but I had a case and we're preparing, and it was one of those cases we could have resolved it 6 months ago. And the district attorney was like, he needs to do 24 years. Really? Really? And I literally asked the young professional DA, have I done something to offend you? Because I get the feeling as though there's some hostility towards me. And she goes, well, it's not you. I just don't like your client. I'm like, okay, that's fine. But you don't have to take it on me. We're professionals. Neither one of us created the facts that have brought us here. We should be professional in our job. I'm like, that being said, can we do something better than, I don't know, whatever it was, 25 years? No. Okay. See you at trial. Well, if you go to trial, there'll be no offers. Okay. See you at trial. Whatever. Not that I was, but it's like, young DA, I've done more trials this year than you've done in your entire life. Whatever. You want to go to trial? Oh, let's go. And sometimes you do well. And like I said, not to tell too many more stories, but we were in court and we noticed right beforehand they had not endorsed the representative from the cell phone records to authenticate the cell phone records. So I'm there, got my client, my associate sitting next to me, and they try to start talking about the records. They call their first witness was an officer. And I'm like, objection, hearsay. Judge sustained it. Because he started talking about, the witness can't just show up and start reading from records. He can only read from records that have been properly admitted. And so, I kind of felt bad for the young DA at that point, but not really, because the young DA had been somewhat rude and mean to me and told me, if you don't take my offer, we're just going to have to go to trial. I'm like, okay, that's fine. And I told him a long time ago, here's the number I need, and we'll do it. Well, let's just say by the end of that day, they couldn't get those cell phone records in. They hadn't endorsed them at that time. That was the crux of their case. Why do they need that cell phone records? Because they needed that to get in the wiretap calls. Can't get the calls in if you can't get the records in to authenticate that it belonged to a particular party. Couldn't get them in, and they tried every which way. And the judge, it was kind of fun at the bench. Well, he keeps objecting, and the judge was like, that's his job, and and I'm sustaining him. The following morning, I was like, oh, this is getting good, right? This is good. And then we got an email. Will your client take the offer that, you asked for before? And I was like, yes. Oh, and by the way, could we make that nunc pro tunc back to the date previous in time when it should have been offered? And the young DA was like, yes, of course. And I was like, that's a good cell phone story. And so that's what when I talk about, the cell phone records and, it's going to be the demise of Lori Vallow and Chad Daybell, is that there's so much information that's there, but the DAs have to make sure they get it right. Okay. Because if the DAs don't get it right, they're going to be sitting there like that young DA thinking, my case is completely falling apart. It's very obvious to the jury that I have no clue what I'm doing, and why should I now trust you? It is simply, it's not as easy as everybody thinks, right? And the thing is even in the federal districts, there is a split as to how this comes in. Why? Because I've litigated that issue. Some judges are like, well, it's a business record. It comes in. Okay, judge, But the witness just said he can't say who put that up, who had access to his phone. You can't even say that the account comes to my client, but yet you're attributing it to my client. You're not bringing in anybody from Facebook. You're not bringing anybody from Instagram or anything along those lines to authenticate it. And some judges are like, it doesn't matter. It's just a photograph. Okay, when was it taken? When was it modified, Judge? Let's look at the metadata. And nobody cares or nobody asks. And let it in. And it's just irks me to death because the rules of evidence are there like any other game, process, whatever, business. There's rules of the game. And those that do well know the rules of the game as to where they can push it and where they can get things in. And so when it comes to, like I said, the Lori Vallow case here, people need to be careful that all their hopes are not hung on those cell phone records. Okay. It's like I said, because it's not that easy. And here's the other thing. We've all heard of the Fourth Amendment, correct? You have a right to be free from unreasonable search and seizures in regards to your person, property, and papers, right? Well, the United States Supreme Court has said this is the equivalent of, if you go back, adopting it to modern day, is that anything where you would keep things of value. I mean, think about it, all your information, your banking information, passwords, texts, emails, private, intimate things on one's cell phone. You have an expectation of privacy for that, okay? And so when, let's say they arrest the bad guy, they take his phone, and I swear to God, this used to happen. The cops would say, hey, their defendant, why don't you make things go easy on you? Why don't you give me your password into your phone? And I'm sure everyone's heard of cases where people refuse to give up their password and people are going to be held in contempt and whatever. And no, can't make them give up the password. So then they say, fine, we'll hack it. We'll get in another way. We'll do a cell phone dump. So the officers would go and they would get, Scott, don't forget it's here on Facebook. No, I'm not. I'm looking at, I haven't got, saw the question scroll by. Don't forget it's on Facebook. No, I'm looking at, I'm just kind of finish this thought here when it relates to cell phones. So the detectives would then go and they would get a warrant. And they'd say, hey, Judge, we think there's a thing of evidentiary value on this phone. And basically, we're pretty sure it's there. We're not sure it's there for sure, but probably likely, more than likely. And basically, the courts have ruled that that's a general search in violation of the Fourth Amendment. And so we've had several cases, probably in the last 3 years or so, where everything was thrown out. Everything was thrown out that was on the phone. And, some of it was incriminating, some wasn't. But just like the founding fathers said, in regards to the Fourth Amendment, the king doesn't get to come through your house and say, we're not sure what you've done. We think it's bad because we don't like you. And therefore, we're just going to look around a little bit and we'll know it when we see it. And that's why we have the Fourth Amendment, because that took place. And so courts have ruled that when you do that, when the police do that, they aren't very specific as to what they're doing. That's a general search. And they do a cell phone dump and they get every ounce of data. And literally you could have 1,000 pages from a cell phone dump, all wiped away because the warrant was not specific enough. Okay. And I blame a couple people. One, the police officer for not knowing that, but how are they supposed to know that? They're supposed to be trained usually by the DA on changes in the law. So it's DAs that didn't do that. And then the judges approved it themselves. And usually it takes appellate courts to correct the errors of the lower court, whether it's a magistrate sign warrants or what have you, because the other courts give deference to that judge. But It's like, Judge, it's a general search. That's prohibited under the Fourth Amendment. Why are you allowing this? Your job is to be the independent, neutral magistrate to look at this and decide if there's probable cause or if it violates the Fourth Amendment. Your job is not to rubber stamp it, which is always what, seems to happen. Okay, somebody said there was a great question here on Facebook, so I want to go to that very, very quickly here. And I just need to see where that was. Hello, look at all the people we have on Facebook tonight. Wow. You have a shifty friend. Don't lend them your phone. Yes. Don't give her. I mean, your phone is like your safe these days at home, right? You're not going to let the police just go rummage through your safe. Oh, I got nothing to hide. No, you're not going to do that. It's just the way it is. We got people from North Dakota. Currently in the hospital. Oh my gosh. Well, wish you well there, Ann. Sonia, Scott, do you think the emails, phone records in the Vallow case, besides any DNA did they find on the children's body, will bury Lori and Chad? Well, I think yes, possibly if the prosecutor does it right and if the searches aren't attacked. That would be probably from the defense perspective, all those warrants of each and every, the warrants for each and every search warrant that was obtained, you have to challenge it, assuming you have standing. But then you're going to have authentication issues, okay? Not just that the documents are there, but you have to have somebody come in and authenticate it. Otherwise, it's still hearsay. Those records that are just being kept at Facebook, it's not like the bank where they purport to say this is the accurate thing, right? You can delete posts. It's there, but you still have to bring in the person that wrote it, unless it's a party opponent to do that. But if somebody else is writing it, they have to come in. If that person's not there, it's hearsay. Only way you can get around that is maybe it's in furtherance of a conspiracy. That would be a non-hearsay statement. Now, I can probably see some people's eyes rolling over. What is he saying when he means hearsay? Okay. Esther Chin, what are you talking about? Well, we'll see. See if they got it, gave it context. We've been talking about lots of things, particularly phones and search warrants, simply because a lot of people have been talking about phones. People said I was encouraging people not to take their phones when they commit crime. But then we rolled that into Lori Vallow and the search and how it is done. All right. So then let's roll to hearsay. Okay. Now, everybody thinks they know what hearsay is, right? Can somebody give me a good definition of hearsay? Do I have somebody sitting in the front row raising their hand that would like to let me know? Jen Lowe, perhaps. Okay, you got to run. Good seeing Jimmy. Wait, when they cut my channel. Oh, that's unfortunate, Jimmy. Sorry about that. Do you have an opinion on the police no longer being able to lie to minors in interrogations in Illinois? Lucia Dance, yes, I do. Let me finish my thought here on hearsay first, and then we'll get back to your question because it's a good question. Yes, the police should not be able to lie in that regard. So hearsay, an out-of-court statement being offered for the truth of the matter asserted, right? So think about it. That's why police reports just aren't submitted. I always get people say, well, I don't want to show up for court. It's really busy. Can't I just do an affidavit? No, not admissible. Hearsay. You have to have, that's why we have people come to court. Okay? You hearing what somebody else said 3 layers down is not accurate. The defendant, has an absolute right to cross-examination, all right? The confrontation clause in the United States Constitution is the greatest truth-seeking tool ever invented, okay? And that's why I can't watch TV. I can't watch these talking heads that just get up and say something and nobody challenges. Like, Are you kidding me? I could prove that wrong in 2 seconds. Where did you get that data? Because there's this data. I mean, it just drives me bonkers, and nobody challenges it whatsoever. And that's why I love going to court. In court, people have to answer the question. You can't say, well, I don't know. Okay, well, that's your answer. You don't know? Great. That goes directly to your credibility. Okay? You can't testify as to what somebody else told you. Okay? Even police officers, right? They write these fancy reports, what everybody told them. Police officers, most of the time, don't get to testify as to what somebody else told them. That's hearsay. An out-of-court statement not made in court under oath by someone other that's testifying on the witness stand. And the witness can only testify as to what they saw, they heard, what they said. Sometimes what another person said as reaction to what they then did. What did you do? Judges always say, what did you do? Well, he told me that there was a fight and he hit her. Objection, hearsay. Oh, it goes not for the truth of the matter asserted. Okay, well, then it shouldn't be allowed as relevant if it doesn't go to the truth of the matter asserted. And you try to tell a judge, hey, judge, I know you've been in law school like 6 years now and you're a judge, but let me tell you, you can sustain that and simply say, have the DA rephrase it and say, did you have a conversation with the witness? Yes, I did. Without saying what the witness said, what did you do in response to what that witness said? I did this. And they went away, right? So you didn't have an out-of-court statement by another person coming in, not being subject to cross-examination. Okay? That's why prosecuting a case is actually a little more difficult than people say, because, I got 4 pages of paper here about what old Alex said at the time. But guess what? Alex is gone. It's not coming in, right? So, that's why you have cross-examination. Greatest truth-seeking tool. All right, we had a question and said, what do you think about Illinois not being allowed to lie to minors in the interrogation process? That is a good thing, okay? And I get it. Police, and there's a lot of cases going back all the way to Supreme Court that says it's okay to lie to a defendant. The classic case, and I can't remember the name, but they're like, oh, you're lying, man. We're going to hook you up to this machine. It was like a copier machine at the time. And, they would hit the button after they asked the question. It would spit out lie. And the guy's like, finally, I confess. They lied. They manipulated to him. So I get it. And cops say, hey, I got your co-defendant next door. You're both going down. He's rolling on you. He's not your friend. You might as well roll on him to save yourself. Adults, they're big boys. I kind of get it. It's just, I don't think that's over the line. You're not beating people up, because a good client, a client of mine, would whip out my card and read it. If they weren't smart enough to say that, they would just simply say, lawyer, lawyer, lawyer. Well, juveniles are not as sophisticated as adults, right? We've all seen the research that says juveniles, particularly young men, let's face it, they're stupid till they're about 25, right? They just aren't making good decisions. Women mature much sooner. I get that. But a lot of states require, if you're going to interrogate a juvenile, that the parent be present and that they consent. In Colorado, we have that. Some states is not the case. But the reality of it is, it's just kind of fundamental fairness. We're the good guys, right? We're supposed to do it kind of cleaner and better than everybody else, right? At least that's I think the ideal that we have, that we are not beating people. We're not tricking people into pleading, making false statements. And you see when the police lie and pressure, particularly juveniles, they confess to anything, right? I had a case once where the guy was like, why don't you just admit? Why don't you just say this? And the client was like, I'll say whatever you want me to say, I guess, but it wouldn't be the truth. Thank God it was on video, because you know what the police report said? Defendant confessed. Okay. So yes, I think police shouldn't lie, particularly juveniles. Hopefully they can get the information some other way, even on adults. But like I said, if they were smart, they would simply say, do we have that queued up, Frank? That we could play the lawyer?
I don't have it here, but
Oh, okay. All right. We'll come back to it. Or they would pull out my card and they would read the best legal advice that they could get on the back of a business card. And what does it say? You might ask. I think I've read this before, but I will tell you. I refuse to consent to any search of my premises, the location of my arrest, my car, or effects. I wish to exercise my rights under the 5th and 6th Amendment to remain silent and to have my attorney present during any questioning or lineup. If you ignore my exercise of these rights and attempt to procure a waiver, I wish to confer with my attorney prior to any conversation with law enforcement agent on the subject of waiver. And then I put my cell phone number so clients can call me in the wee hours of the morning and say, Scott, what are they doing? Scott, this is what they're doing to me. And I will say, hey, stop talking to my client. He's represented. Because once the client says, even unrepresented, says lawyer, the cops have to stop the interrogation. Just the way it is. All right, Krista has a question. Oh, it's not really a question, it's a statement, but thank you for the super chat and the nice words. Love watching your channel and all the hard work you put in. One of my favorite channels to check in on a daily basis. Thank you very, very much. That's very nice. Thank you for the super chat. Appreciate it. And just so we're clear, like YouTube doesn't pay us big bucks, okay? I could make usually in a day or two what YouTube pays me in a month. Okay. So one of the reasons we started this channel is we hopefully wanted to educate people on the law, how it works, how it really works, because I got so frustrated watching the news when some news person who had no idea what they were talking about, they didn't know the difference between an arraignment and a preliminary hearing and a sentencing hearing, gets up and starts babbling. It's like it's completely incorrect. Okay. And sometimes maybe I should be a little more sensitive, but I've said this before. Nobody has a right not to be offended. Okay. That's just the way it is. There's lots of things that offend me. It's part of life. And my job is I have to deal with trying not to offend everybody, a jury, a judge, the prosecutor. But sometimes I've found in doing this for 26 years, honesty is the best policy. Just tell the truth. People may not like it. Your kids may not always like the truth. I think I said this in the show today. My daughter, I love my daughter dearly. And she was sending me something. I'm like, okay, fine. But I don't think that's a good idea. Oh, well, gee, you're kind of... she was wondering if she should ask for, is it going to be the grumpy? You can text me anytime you want. You can call me anytime you want. But I'm going to tell you the truth. I'm going to give you my advice because, that's what I do. Yes, I'm going to be sensitive to you. I understand, etc. But at the end of the day, I got to tell you the way it is. And I told her, I was like, I don't think that's a good idea. I think you should do this. It's up to you. You're an adult. You're going to be 25. And if you want to buy a condo versus a home, just be careful. There's lots of hidden fees, etc. So I don't know. We'll see. I think you just got to tell the truth, tell it the way it is, and stick to the truth, the facts, because you get down that speculation road. Look at all of these people that, like I said, we could sit and speculate all day long. When that Chris Watts thing was going on, I was saying whatever these crazy theories were, I was like, are you kidding me? Is that going to be admissible in court? And if you've cracked the code, instead of putting it out on Facebook, you should be calling the police immediately. And if it's legitimate, they'll look at it. So I got in trouble like that. Oh, you're no fun, Scott. You don't like to speculate. Listen, I am a realist. I am the mayor of Realville. The only thing that matters is what can be proven. Bottom line. Julia, thank you for answering my question. Hopefully that answers your question. Looking here on the Facebook questions here. Cop was too enamored with prissy Miss Lori. Also, they're meatheads. Not my words. Somebody else here sent that in. Yeah, I mean, let's face. I mean, the cops. They noted that Lori Vallow at the Chandler, Arizona, was at the time. She didn't appear to be very upset. Now I get it. It's like it's her ex-husband. I mean, he's dead. Ooh, she probably made my day, right? Now I don't have to deal with him, child custody issues, visitation, charm, so to speak. And that. It says, if you keep talking after you lawyer up because you have a big mouth, can those words be used against you? Good question, Denise. Yes. Okay. And this is what I do not get. Okay. Because not everybody has the back of my business card if they have a weak moment. Just take it out and read it. Right. Although they probably should, because it's best lawyer advice ever. Do we have that queued up yet, Frank? Okay. Denise, this is what someone should say if they are being arrested. Roll tape. Oh, hold on. Okay.
Get up.
Roll tape.
Yeah, you.
All right, lawyer.
Sir, we have a warrant for your arrest. You can get a lawyer when you're in your holding cell.
Lawyer.
William Stern, you are under arrest for insider trading and securities fraud. You have the right to remain
All
silent.
right. That is from the show Billions. That is when Dollar Bill was getting arrested. Why do they call him Dollar Bill? Because he's very cheap. Okay, little side plot there, but it's a great show. And what does he do? Oh, you're coming to arrest me? All right. Lawyer. So that everybody can hear it. Everybody can say he's lawyering up. Okay? Nothing drives me crazier than I have a new client. All right, man. Tell me what happened. Okay. Well, did the police come and interview you? Yeah, they came and interviewed me, but I didn't tell them anything. And, I get a little suspicious. They came and interviewed you, but you didn't tell them anything. Okay. So how long did this interview last that you didn't tell them anything? Oh, probably 45 minutes or so. Yeah, we were just chatting. Oh, you were just chatting. Okay. So then you say, okay, well, why don't you tell me what you were just chatting about when you should have not been talking? And then the client, well, I may have told him I was there. Okay. Because they got to prove that you were kind of there. That's good. On the date and place and location charged. And that you knew the victim. Okay. All right. Well, why'd you talk to the cops? You have to ask the client. Well, I didn't tell them anything. I was just trying to figure out what was going on. Okay. And remember, anything you say can be used against you. Oh, no. I asked for a lawyer. Okay. Well, who reinitiated the conversation? Well, I did. Because the cop said I couldn't talk anymore. Couldn't talk to you anymore. So I asked him, well, why don't you just tell me what's going on? Oh, so you reinitiated on your own the interrogation. Did the police officer then advise you that I can't really talk, but you're reinitiating and I need to advise you Miranda rights? Oh, yeah, I know all those. I don't need it. Yeah, just tell me what's going on. Yeah. Anything that he said is all coming in as an admission of a party opponent. Okay? I do not get it. And here's the thing that has been ingrained in people's head since Arizona v. Miranda. I think it's Arizona v. Miranda, where basically the Miranda rights, you have a right to remain silent. Anything you say can and will be used against you. If you can't afford an attorney, we'll appoint one at no expense to you. Blah, blah, blah. Right? The United States Supreme Court created that. You will not find the Miranda advisement anywhere in a constitution at either the state or the federal level, anywhere. The United States Constitution created the Miranda warning because they thought, hey, these cops sometimes trick these people. They're not the smartest people, but we're going to advise them to shut up. They created that to tell people, we're warning you. Please shut up. You're not helping yourself. Ask for a lawyer, right? Because Supreme Court, they're all lawyers. They're like, shut up. Don't say a word. We'll get you an attorney for free. You hear about it in TV shows, movies. How many times do I get people to call? Yeah, they came and arrested me. They didn't read my Miranda rights, so it was illegal arrest, right? Not necessarily. Did they question you about anything? No, they just came in and said they had a warrant for my arrest, arrested me, took me back to the police station, booked me in. Yep, completely legal. They had a valid warrant signed by a judge. They didn't ask you any questions because they only have to advise you of your Miranda warnings when you're in custody and they're interrogating you. But the United States Supreme Court has said, hey, knucklehead, stupid one, weak moment, not sure what to do. We're going to give you a hint. We're going to make the other team let you aware that you can stop everything right now. Just say lawyer. And how many people? Most people talk. Oh, well, yeah, I was just trying to find out what was going on. He was so nice to me. I mean, I had nothing to hide, right? I was just there. I didn't do anything. Well, they're not saying you did. They're saying you're an accessory to it or a complicit to it. So, yeah. So, yes, Denise, you're absolutely correct. If you shut your big mouth, not you, but if the defendant shuts his big mouth, his or her big mouth, and then reinitiates and start talking, yes, the police should re-advise him. That's the cleanest way to do it. But yes, they can do that, and it happens all the time. Someone say, yeah, I think I want a lawyer. Cop says, okay, I can't talk to you anymore. I'm going to leave you here in the holding cell. And then the guy, the cop's walking by, getting a cup of coffee, filling out paperwork, and the defendant will say, hey, can I talk to you? I got something I want to tell you. I've seen it 1,000 times. And I'm just telling you. And I swear to God, no one ever believes me. And like, oh, Scott, you're a defense attorney. You're not going to do it. What is the first thing a police officer does when he gets in trouble? He gets a lawyer and he shuts up. And you talk to any detective, any cop, they will tell you, oh my God, I'm trying to warn these guys, shut up. And they just keep talking. I mean, the cop loves it because you just made his day a heck of a lot easier. Yep. And the defendant said this, he confessed to this, he did this. Boom, turn over, make the case easier for anybody. I'm telling you, I've had cops tell me, dude, your client just wouldn't shut up. I mean, he just kept talking and talking like we were buddies, thinking we were going to be buddies at the end of this. And I was going to let him go. Not going to smooth talk him, nothing. But that's what they do. And like I said, when police get in trouble, what do? They shut up and they lawyer up. So if it's okay for the police, right? It's always better to look guilty than to be found guilty, ladies and gentlemen. That's the truth. Let's see, you guys share this channel. I've learned about your channel and the other crime channel. I know at every episode I get true and accurate information. Well, thank you very much, Emily, on the Facebook page. I wonder why my question was skipped. Sonia, I'm sorry. I didn't see your question, but let me see if I can go back and find Sonia's question, because we don't want her going throughout the day or even tomorrow and saying, I wonder why my question wasn't answered. Maybe I can get a little help here and see where I missed Sonia's question. Sonia. I'm sure it was a great question, but neither I nor Frank or Julie, the hardest people working in show business, cannot find it. So I apologize, Sonia. Perhaps if you would like to re-ask your question, I will be more than happy to try and answer it. Let's see. Oh, good question, Vicky. When an inmate reports that a fellow inmate confessed to them about a crime, would this not be hearsay and not stand up in court? No. Good question, Vicky Erickson on Facebook. That is an excellent question. Anything a defendant says, anything a defendant says, as long as it's relevant to the case at hand, comes in as a statement as a party opponent. So if you confess, yes, the defendant can say, oh man, that jailhouse snitch, you can't trust him, but man, he sure is doing it accurately, right? That's an admission by a party opponent. It all comes in. The best the defense can do is to simply cross-examine and say, liar, liar, pants on fire. Anything the defendant says, that's why people don't get it. They somehow think, yeah, I mean, like who else would know of what's going on? Well, maybe only the 12 people at the bar, 6 people here that I work with, blah, blah, blah. Okay? That is a statement by a party opponent. Those people could all be called to testify as to what the defendant said, as long as it's relevant to the case. Okay? And so everything the defendant says come in. But you say, but why does the defendant have to choose to testify or not? Okay? Well, the reason why that is that you cannot admit self-serving hearsay. So if the defendant made a previous statement to the cops and said, man, I didn't do it, you got the wrong guy, lawyer, that's it. Okay? So a good prosecutor wouldn't even use that statement, but sometimes one always does. And I'm always surprised. Okay, you're putting in my client's statement where he said he didn't do it. Okay, thank you. I appreciate that. Now my client doesn't have to testify and it's not subject to cross-examination. Right? Perfect. But they do that. But the defense cannot put up the client's statement and say, hey there, detective, did you talk to my client? Yeah, you did. He denied that, right? Yes, he did. Tell me how he denied it. Oh, he said he didn't do it. Wrong guy. Good, right? Nope, not admissible. Self-serving hearsay. So it can't come in. So hopefully you can see just by tonight, when you have hearsay, you have exceptions to the hearsay. And I'd have to look. I think there's some 30 exceptions to the hearsay rule. I'd have to look at all of them. I think it's 26 to 30 exceptions to the hearsay rule where you can't say what somebody else said. So there's all kinds of exceptions. So, and even I have to look them up sometimes, even though I think I know the rules of evidence pretty darn well. A lot of people think, well, I can just do this by myself. It's much more difficult than people say. Aletha Tingy, hopefully I pronounced that correctly. Thank you for that super chat. It's hard to find a realist these days. So you're very refreshing. Thank you for your time 6 days per week. I've learned so much from your channel. Well, thank you very, very much. All right, let's go back here to Facebook and see if we can find Sonia's question here before we are coming to an end. Can you believe it? Okay, Teresa just started following and shared the video. I hope I win the $100. Well, Teresa, good luck. I hope you win it as well. Let's see here. I need one of your cards just in case. Laugh out loud. Didn't we actually have that at scottreisch.com at one point? I can't remember. But it's the back of my business card. I'm telling you, best legal advice you can get. All right. If I had to sum it down any shorter, I guess you could say a fish never got caught by keeping his mouth closed. Right? Where's Sonia's question? Cindy Jones, let's see. When being arrested, keep your mouth shut after you say Scott's 3 favorite words. Lawyer, lawyer, lawyer. Absolutely. All right, I'm looking here. I'm trying to find Sonia's question. This last one in. Let's see here. I'm scrolling. Sonia, I was asking if you feel that Ghislaine Maxwell and John Benet's family were acquainted. I asked because there was allegedly a picture of John Benet with Ghislaine in it with her. Maybe Epstein was acquitted with her. I hope this isn't a bad question. Sonia, not a bad question at all, but I will tell you my answer. I don't know. I didn't know that Jean-Benet Ramsey, obviously of Boulder, Colorado, where no one's ever been prosecuted for the young little girl's death. Obviously a weird case. Lots of theories out there, but you got to be careful with those theories. Could get you sued. I think it was CBS, right? They got sued on that. Lots of people did. You got to be careful. But I don't remember ever seeing the photo with Ghislaine Maxwell and Jean-Benet. Anything's possible. I don't know. But in today's world, you got to be careful. It wouldn't surprise me at all. I think the same firm that represented Jean-Benet's firm also represents Ghislaine Maxwell. Maybe it's just coincidence. Maybe there's some validity. I don't know. Don't like to speculate, but I do know that the same firm represented them. When I say them, the Jean-Benet's mother and father, as well as Shadow asked twice about pool party. Have we ever heard who attended the party? What is that in regards to? I'm sorry, Shadow.
There's a theory.
Was this in Arizona pool party? Sorry, maybe it's just not clicking. Maybe I'm having a brain freeze. Question by Sarah: is it admissible if a record is made of what someone said right after hearing what someone say, after hearing someone say it? Would the record of that be admissible if the person made the statement was not able to testify? Probably not. I mean, there is a contemporaneous records exception, but it has to be kind of kept in the normal course of those business records. So what pops to mind to me would be, say, for example, you call your credit card company and they say, hey, these are all being recorded, and you have somebody there taking copious notes of what you said as to what was being said. And if those were kept in the normal course of business, it could be as a business record. So the question is, depends. Probably depends on the relevance, the strength. How can you authenticate that was really said? How do you know that was the person that made the statement? But yeah, and it can't just be some random person, that's making. I mean, there's exceptions to all of those, but good question, Sarah. It depends if it's an actual business record. Otherwise, that would be hearsay. All I know is a general rule: when somebody starts saying what somebody else said, I object, hearsay. Let's sort it out at the bench. Bottom line. Okay, yeah, thanks everyone for super chat support. All right, now guess what? It's that time that has come, ladies and gentlemen. Want to thank everybody for watching this evening. Want to thank everybody who has joined us not only on Facebook, but YouTube. Please like, subscribe if you haven't done so already. Share it with a friend. I appreciate that. But now it's time to go to our Patreon show. And if you haven't joined Patreon, you can join for as little as $5, okay? And like I said, I'm not taking extravagant trips on the money that nope, it covers general expenses. This stuff is time consuming, particularly for Frank. He's got to edit. And Julie's always posting something and doing something. So, I mean, it's time consuming. Obviously, we want to keep good people. So any money you get helps that out. But like I said, not for me. I haven't been able to quit my day job just yet, but we appreciate all that you do. So when you buy a shirt, you join a Patreon, you become a member here on Facebook, Super Chats, all that goes to the operation of this because, well, that's what we use it for. All right. So thanks for all the great questions. Thanks for all the great questions on YouTube and Facebook. Thanks everyone for joining us on Facebook. Remember, if you like, share, and subscribe, and you share that, the first 100 people will pick one person, give them $100, and do the same up to $500. That's right. The pros behind me here tell me we need to get those Facebook numbers up. So that's what we're attempting to do. And I always love a good challenge. So that's what we're going to do. All right. Thank you for watching. Hope to see you all shortly on our Patreon page. You can get that link as a Patreon member. We'll see you in about 5 minutes. Have a wonderful day. We'll see you next time on Crime Talk. And don't forget to go watch the video today.